Hi, everyone. My name is Eric Buchanan. I'm the attorney who founded the law firm of Eric Buchanan and Associates. We've been helping people for about 25 years who have been denied long-term disability and individual disability insurance benefits. And a lot of our clients come to us with insurance problems and they don't understand why their cases are so complicated, why they don't have the rights that other people have, what makes their cases so difficult. And one of the things I wanted to talk to people about is a federal law called ERISA, the Employee Retirement Income Security Act of 1974. That law applies if you have life insurance, health insurance, long-term disability insurance, other insurance like that you got through work, and you got it in a way that the employer was involved at all in providing the policy, which it almost always is, then that law applies to your case, and it totally changes how your claim can be handled, what the rules are, what kind of rights that you have. And so if you are denied long-term disability or individual disability insurance benefits that you got through work, or if you're denied a health insurance claim or a long-term care claim or a life insurance claim through work, any of those kind of situations, you need to be aware that ERISA totally changes the rules. I highly recommend that you get an attorney involved who understands ERISA and can help you get through the difficult minefield that ERISA creates. So let's talk a little bit about what ERISA is, where it came from, and what it actually does to change your rights when it comes to an insurance policy. So back in the 1970s, there were a lot of problems with the American pension plans. The large employers offered these large pensions, and sometimes unions offered large pensions, and they had big pension funds, and they offered decent retirement benefits for their employees, for members of the unions, for the people who were covered on these pension plans. But sometimes someone would try to steal money from the pension plans. If you've ever seen the movie on Netflix, The Irishman, it covers a guy named Jimmy Hoffa. One of the things he did was he was involved in the Teamsters Union, and he was accused of taking money from the pension plan. So Congress responded to that by passing a law in 1974 called the Employee Retirement Income Security Act of 1974. That was the full name. And in that law, Congress provided a national federal law that would allow people to sue if their pensions were stolen from, their pension plan was mishandled, if there were bad investments in their pension plan, and otherwise employers were trying to do stuff wrong with pension plans. The problem with ERISA that ended up affecting people who have insurance claims is that ERISA was expanded by Congress at the last minute as it was going through the legislative process, as it was a law about to be passed, to include not just pensions, but other employee benefits. So other employee benefits like long-term disability, life insurance, health insurance, those kind of claims fall under this federal law called ERISA. And so ERISA then takes those kind of claims and says, if you are denied by your insurance company, they're not paying you the long-term disability benefits or the life insurance benefits they're supposed to pay, you cannot just sue that insurance company under the normal rules you would have in your state's courts. You have to deal with this federal ERISA law. So what does it do differently? Well, ERISA does several things that hurt your case. It will require you to follow this federal law. Usually the insurance companies can make the case end up in federal court. Either you have to file the case there or the insurance companies can remove it to federal court. It's often a surprise to attorneys and people who are not used to dealing with these type of insurance claims through work, and they don't understand ERISA's rules. So that's a problem. You end up with something called a closed record, where you have to get your information to the insurance company before you ever go to court. There's also something called exhaustion, where you have to go through all the steps before you're allowed to go to court. There's also changes to the rules that would normally apply to an insurance case. For example, the federal law allows for the insurance companies to have a higher standard of review in court. In other words, they get the benefit of the doubt. You don't have the right to a jury trial. And you also can't sue for things like punitive damages to get extra money for the insurance company. So let me walk through some of those things. But I'm going to start back at the beginning. Was ERISA really supposed to be this kind of bad law? And the answer is clearly no. If you look at the history of ERISA, the politicians who passed the law thought that they were helping ordinary working people by providing this law that would provide this extra protection for their benefits. One of my favorite quotes is President Ford signed the ERISA law on Labor Day, 1974. And he said, I think this is an historic Labor Day, Ford said. Historic in the sense that this legislation will probably give more benefits and rights and success in the area of labor management than almost anything else in the history of our country. And that's a quote I'm getting from a book called ERISA, A Political History by James A. Wooten. Another quote from that book I think tells it even better. Senator Javits from New York was very instrumental in getting the law passed. And he said, this pension reform bill is the greatest development in the life of the American worker since Social Security. That's how much the politicians believed in ERISA. So what went wrong? Why did it change? Well, early on, in early litigation, insurance companies, other people who provided benefits, pension plans, they were afraid that ERISA would provide too much protection for employees. And so they tried to get out from under ERISA whenever they could. And one of the first whole series of cases from the late 70s and the 80s were courts saying it's really hard to get out from under ERISA, that the law ended up being interpreted that anything close to an ERISA plan would fall under ERISA. All insurance benefits that people get through work are almost, well, not every single one, but almost all of them, a huge percentage of people's benefits. You can almost assume that if people get their benefits through work, they're going to fall under ERISA. It just happens that often. And that's in part because ERISA was supposed to protect people, and in part because the courts originally made it very hard to get out from under ERISA. But then things changed. The insurance companies started arguing in court that under ERISA, there should be special rules in their favor using the concepts that Congress put into the ERISA law. And so what do I mean by that? Well, one of the concepts they put into ERISA law is that these ERISA benefit plans and insurance plans are not just ordinary insurance policies. The employer and the insurance company are supposed to act like fiduciaries. You've probably heard commercials on TV where investment companies say, we're fiduciaries and we will help protect your benefits. We can be sued too. Well, that's what the insurance companies are arguing in these early cases under ERISA, is that they're fiduciaries because that's what the law created. But instead of having the special obligations of being a fiduciary to protect the benefits, they also argued that they should get the privileges of fiduciaries. Well, what does that mean? Well, that means they can write their policies and these benefit plans in a way that if a court looks into what they were doing, the court can give them the benefit of the doubt. The court would apply a lower standard of review for them to do what they're doing and a higher standard of review for people who are claiming that their benefits are denied. And so they made those arguments. And in 1989, the Supreme Court decided a case called Firestone Tire versus Brudge. And in Firestone Tire versus Brudge, what happened was the question came up, should these ERISA cases be decided under a standard review where both sides' arguments are weighed the same and whether the insurance company or the person who's being denied the benefits are treated the same, or does the insurance company get the benefit of the doubt? And different courts around the United States have decided in different ways. So the Supreme Court took this case up, and Justice O'Connor spent most of the decision writing this long opinion explaining why ERISA is supposed to protect people more. And under the ERISA rules, people are supposed to get better protections than they got before ERISA was passed. And so the default rule under ERISA is that the court would review cases de novo, which means it weighs each side equally and applies just the ordinary rules that you would apply to decide if someone was right or wrong. However, she created a loophole at the end of that decision. And she said, but under fiduciary rules, under trust law rules, which apply in these ERISA cases, there's a special rule that says if you put a plan together that says that the insurance company or the decision maker gets the benefit of the doubt, that they have discretion, then they have a different standard of review, and that's permitted under trust law. The problem is that became the loophole that almost all these cases fall under, that this loophole says that the insurance company gets the benefit of the doubt in court under an arbitrary and capricious standard of review. What does that mean in plain English? That means the insurance company can win even if they're still wrong. They can win as long as their decision was reasonable if they have that language in their policy. Now, there's some modern changes to the law over time. What language counts to give them that discretion has been fought over. Some states have passed laws limiting discretion, and there's a special exception to ERISA where certain state laws regulating insurance might still apply. So that might be a rule that applies in some states. The Department of Labor also issued some regulations that came out at the end of the Obama administration that were put out in the first Trump term that also basically say that if insurance companies don't follow the rules, they might lose their discretion. But unfortunately, in a whole lot of ERISA cases, the insurance companies still have this discretion, so they get to win under an arbitrary and capricious standard of review, which in plain English means courts will say they can be wrong as long as they're reasonable about it. And if you're weighing evidence, things like medical records and medical opinions, the insurance companies are allowed to basically win if their position on believing that evidence is considered reasonable by the court, even though a court might have gone a different way if they were deciding the case. If they were deciding the case under the de novo standard of review. So there's the problem of how that happens when these cases actually get to court. But there's an even earlier big problem with ERISA cases that people need to understand, and that is that there's a closed record. So another decision that courts made in the 1990s was, how are these ERISA cases handled in federal court? Well, the courts decided that you don't get a jury trial, and that the court would only consider the evidence that was submitted to the fiduciary, which means the evidence submitted to the insurance company. So what does that mean in plain English? That means there's something called a closed record. It means that the federal court will only look at the information the insurance company has in their file. And if that's information they gathered, the insurance company gathered, it's going to be all in their favor, or it's going to be mostly in their favor. What you have to do to fight that is you have to get your own information submitted, and it's not just your medical records, but it's getting opinions from your doctors, it's getting medical testing done, it's getting things like functional capacity evaluations done, other tests that you can do to prove you're disabled, or if it's a life insurance claim, it's other evidence about why you were properly covered or why the person who passed away had the insurance in place at the time. The information that can actually help you win the case. All of that has to be submitted to the insurance company during the claim process. If it's not in the record when the insurance company makes their final decision, then it's not something the court can look at. Even if it's really important information, if it comes up later and it wasn't submitted to the insurance company, it doesn't go before the court. The court does not look at that information. So it's a closed record. That's something that almost every circuit court in the United States has adopted as one of the rules for ERISA cases, and it's something you have to deal with all over the United States. So that's something people have to be aware of. Another problem with ERISA cases is that you don't get a jury trial. You have a federal judge deciding your case under the standard review. People are thinking often when they come to us that, well, I've got denied by this insurance company. I want to sue the heck out of them, and I want to get all the money they owe me plus some extra money, and I want a jury to find that they acted in bad faith, or I want a jury to give me punitive damages, and I want a jury to find that they were guilty as hell. Well, none of those things can happen because there's no jury trial. The case is decided by a federal judge based on the records that were submitted to the insurance company, and often under the arbitrary and capricious standard review. And here's one last problem. What I just said about our clients, they want to punish the insurance company. Well, another problem with ERISA is that you cannot sue for anything more than the benefits due under the terms of the plan. Under the plan, you might have a certain amount of long-term disability benefits they're supposed to pay you in the past and start paying now. If it's a healthcare claim, the insurance company has to pay for that procedure or whatever the medical expenses were. If it's a long-term care claim, they have to start paying the amount that they have to pay to let you stay in the nursing home or whatever the long-term care facility is. If it's a life insurance claim, they have to pay the amount of the life insurance. But they don't have to pay beyond that just because they made a bad decision, because they left you out there with no money, because they made you live without your income for a while, because they didn't pay the money they were supposed to pay. Another rule about ERISA is there are no punitive damages. There's no damages beyond the amount due under the policy. Now, there's one little exception for that. Courts can award attorney's fees in cases that go all the way to the end of the case and you win, and then the insurance company can be forced to pay some amount of attorney's fees, but it's not usually enough to cover people's whole attorney's fees. It's a little bit. It's normally not enough to really make a big difference and punish the insurance companies. Why is this so unfair? Because insurance companies can deny thousands and thousands and maybe tens and hundreds of thousands of ERISA claims every year. And if they get caught on a few of those where people actually sue and get a good attorney, the insurance company might lose a few of those where they have to pay attorney's fees. But overall, it's just the cost of doing business to the insurance companies. They end up denying people all the time, and there's no financial punishment for the insurance companies. At the end of the day, the worst that happens is they have to pay what they would have had to pay in the first place. But if they win in court, then they don't have to pay. So the only expense for denying people all over the United States is the cost of paying their attorneys and occasionally paying the other side attorneys, which doesn't happen very often. So those are just some examples of ways that ERISA has turned into an unfair law. It's a, it doesn't allow for people to have the benefit of our traditional American justice system, the right to a jury trial that's guaranteed in the Constitution. There's some special rules why courts have said that doesn't apply in ERISA cases. We'll talk in more detail in future podcasts, but I wanted to just basically start this conversation with people who are concerned about ERISA or concerned about whether their policy is covered by ERISA, if they have become disabled and aren't sure what to do about their claim. The simple answer is you got to understand how this stuff works. And if you have any questions about that, if you've been denied long-term disability benefits, life insurance benefits, long-term care benefits, a large health insurance claim, reach out and find us on the World Wide Web at buchanandisability.com. Reach out and find my firm. We have 6 attorneys that handle these cases all over the United States, working with local attorneys in states where we're not licensed. We've been handling these ERISA cases since I opened the firm in 2003, and I've been handling these cases since the late 1990s before that. So if you have any questions, once again, please reach out to us on the World Wide Web at buchanandisability.com.